Welcome to this edition of Legally Speaking. I am your host, Leanne Wiley, and I am here with attorney Sarah Vogel. And I want to invite everybody to subscribe and hit the thumbs up button down below so that you can stay caught up on all of our new features. We are going to talk about non-competes and non-solicits today. So first, Sarah, why don't you tell us a little bit about yourself?
Sure. So I live in Oregon, and that's where I'm licensed to practice law. And I, in 1997, was licensed as a hairstylist and esthetician. And that is what I did from then until 2010. And I owned, during that time period, 2 different booth rental salons, and also worked as both a commission stylist and a booth renter in various salons prior to opening my own. In 2011, I went to law school, and here I am since then. I'm actually still licensed in hair and aesthetics in Oregon.
Well, excellent. We do need to kind of go over a disclaimer. Just, is there anything that you want to disclaim so that when go ahead?
Yeah, so, to make clear, I'm an attorney licensed in the state of Oregon only, so not licensed to practice law in any other jurisdictions. And the information, what we're going to be talking about today, this is information. It is not legal advice. I don't know the situations of anyone who may be watching this in order to advise them about what they should or shouldn't do in their individual situation. And again, I'm only licensed to practice law in Oregon, so nothing that we say here should be construed as legal advice, as advising anyone how to act or move forward with any particular situation they may be encountering. I'm an attorney, but I'm not your attorney. And so, right. This is all information to give a sort of information and jumping off point for everyone. But if you're having a particular situation that you're dealing with related to this issue, really any legal issue, but this is a particularly complicated area and the laws vary widely, which we'll talk a little bit more about. So if you have a non-competition agreement situation that you're dealing with, I strongly encourage that you speak to an attorney licensed in your jurisdiction, who practices in your jurisdiction and is experienced in your jurisdiction, because they're going to know not only the laws, but the court decisions that affect those laws in your particular area. And this is an area of law where there's a lot of variation between the states and a lot of different factors that can influence it. So before you do something or don't do something that might affect your legal rights, you need to speak with an attorney licensed in your jurisdiction, because what we're talking about is just general information.
Right. So let's kind of get started with what is the difference between a non-compete and a non-solicit?
Sure. And this is a really important distinction, because although non-compete agreements are pretty regulated in most states and have a lot of various restrictions, non-solicitation agreements are generally allowed. Even in states that might severely restrict a non-competition agreement. Again, there can still be some variation in the specifics of that, but a non-competition agreement is going to restrict the type of work or the location of the work of the employee. So a non-competition agreement is going to be aimed at what and where the employee could operate after leaving the employment of the initial employer. A non-solicitation agreement is aimed at the customer or client base of the employer and preventing someone leaving from trying to siphon off or solicit those customers or clients to come over to their business. So a non-competition agreement might include a non-solicitation clause, but you could have a non-solicitation clause separate and apart from a non-competition agreement. And additionally, and we'll probably get into this a little bit more later, you could have a non-competition agreement that was otherwise unenforceable, but that wouldn't necessarily mean a non-solicitation clause was not enforceable.
Okay. So why do salon owners feel the need to have these agreements?
So, I mean, I think there can be a lot of reasons, but generally speaking, for people who've never owned a business, a salon or any other kind of business, sometimes it can be sort of hard to understand this, but there is a cost to bringing on an employee. How much that cost is going to depend on what kind of benefits they offer, what kind of setup they have to do, whether they offer initial training or ongoing training. But regardless, there is always a cost to bringing an employee on to a business. And so for the employer, they're expending this cost, and particularly if they offer a training program that they're going to pay for. And so they have an interest in the success of their own business to not expending all of that money and then having somebody immediately take that knowledge and training they've given, take it somewhere else to profit off of it, leaving that, company that provided all of that training out the money and without the employee to do the work.
I do know, just to give kind of a reference point, when I was the hiring manager at a bar and restaurant, our corporate told us that it cost them $7,000 to hire one employee, like
Right.
one waitress or one bartender. So that's just kind of a reference point of how much money goes into actually hiring somebody. So I would say that for our industry, it would be a lot more.
I would say so. And again, it can vary too, depending on what kind of training they're providing. Obviously, with COVID, things are different, but particularly before that, there are companies who would send people to, shows and training courses in another state and all the costs associated with that, or they might bring in a trainer to give a training to all of their employees, and those can be quite expensive. So those are just some of the costs. And then if you're providing benefits, there's a cost to setting up a new employee in the benefit system every single time as well.
Well, and then there's like the added hours that goes into advertising, the added hours interviewing, the added hours to train that employee. Like you have to, if you have a manager or a senior stylist who is going to train them, you're paying 2 times the amount for each hour that they're there. So, I mean, it's not, I think that what happens is stylists who are not owners get kind of have a mentality that it's just salon owners being greedy. When really, in all honesty, it's salon owners kind of protecting their own business, because we're not running charities here. We're running, businesses.
Right. And I think, we all are limited by our own experiences, right? So, and that's one of the reasons why I am wanting to get involved in this, because, the salon industry is sort of its own unique thing. And I think that people who've never been involved in it, working in it, can't necessarily understand how it operates, how there's often this culture of we've always done it this way, and those sorts of things. That I have a different understanding of, having worked in it for a number of years, on both sides of the equation, having been both an owner and an employee. And I think that, a lot of stylists who've never been a renter even, because renting does give you some insight into how overhead works, and that the costs are maybe more than you think that they are. But if you've never done any of those things and never owned a business, then it can be difficult to see sort of what those costs are and why a salon owner might want a non-competition agreement, other than just feeling like they're trying to control you.
So then can either of these agreements actually benefit the stylist?
Well, it's interesting because, I mean, certainly the aim of a non-competition agreement is to protect the employer. However, I think that what's overlooked a lot of times is the benefit to the other stylists in the salon. So, if I work at Salon A and there's 10 stylists at Salon A, and we've all been trained and maybe trained in a particular technique of, extensions or coloring or something, and one of our stylists leaves and takes all of that knowledge and the sort of special techniques or experience that our customers have come to expect from us, and opens a competing salon across the street, that doesn't just siphon clients from the salon, it siphons clients from all of the other stylists. So that's going to have a negative impact on the income and business of all of the stylists who remain at the salon that the other stylist has left. So, it's sort of a collective benefit to all of the employees of a location to not have one person be able to kind of take all of that away when they go.
Right. Are there any states where a non-compete agreements for our industry are not enforceable?
So there are, let me put it this way. Yes, probably. So for example, in Oregon, which is where I work, it is possible in a very specific type of circumstance that I suppose you might be able to shoehorn a stylist into one of the categories where non-competition agreements are allowed. It would be very difficult. I'm a lawyer and we never say never. So I can't say never, but I know for Oregon, at least, it's pretty close to never. And part of the reason for that is in Oregon, one of the requirements to impose a non-competition agreement on an employee is that their salary has to be at least the median income for a household of 4 in the state, which currently is $100,533 a year. So if you're paying your stylist less than that, which I think we all know the vast majority of stylists are being paid less than that. I'm not going to say all of them because there might be a couple somewhere that are rocking it. But generally speaking, the average income for stylists is about 1/3 of that. So that's unlikely. So if you don't make that much, then a non-competition agreement is voidable in Oregon. So, and there's other restrictions too on type of work that would also, I think, limit how it could be applied to stylists. But the income limit alone right there is going to kick out 99% of stylists. And various other states have similar restrictions. There might be restrictions on the type of employees that can be covered. There can be restrictions on, well, let me back up. So there are a number of different kinds of restrictions on non-competition agreements. I will say there are only a handful of states that do not allow non-competition agreements, period. Like less than 5. It's a very small number. There are a lot of states that put a lot of limits on what can be in a non-competition agreement and who a non-competition agreement can apply to. So some of the different types of limits that you might see in the statutes in a different state would be a type of work. In some states only include certain industries, like maybe the tech industry or something along those lines, research and development type things where you might have learned proprietary or trade secret information. Other states exclude certain categories, like, okay, you can have a non-competition agreement, but not for physicians or not for social workers or not for, they might have a category that's excluded. Additionally, there might be limits as far as like an Oregon income. There can be limits also as to the reasons why an employer can have a non-competition agreement. So in most states, there has to be a protectable business interest for the business to have a non-compete agreement. Now,
would that be like trade secrets? Because I know in Nebraska, yeah. Only because I'm from Nebraska, so I've looked into it extensively, but it only covers trade secrets. Right. So would Salon fall under like trade secrets?
I think so. Again, it's going to depend on court decisions in your given state. Right. I think broadly that would be unusual for a salon to have trade secrets. However, I can certainly envision a situation where it might. So, we're all familiar with there's, various systems for, I'm just going to use an example, hair extensions, right? And some of them have proprietary application systems for hair extensions. So if a salon has something like that, or is maybe, you know, this hair extension company has a, you know, flagship salon in, you know, X location where they do all the training for and are known for this particular proprietary type of application method, or you know, proprietary type of hair or whatever.
Or maybe if a salon had their own line of products.
Yes, yeah, something like that. Then in those situations, I could see where a court might say, well, this does qualify under that. So again, it's, you know, a little bit sort of situation dependent, and also dependent on what that state's prior court rulings have determined. There are probably court decisions in any state with these types of restrictions that are going to address, so what do we mean by a trade secret? What do we mean by a proprietary business interest? You know, those sorts of things. And so this is again why we say you want to talk to someone who is licensed in your jurisdiction if you're having an issue with this, because they're going to know what those decisions are in your area, and you know how judges are applying it where you are, because that can also vary within a state by area. You know, certain areas might be more conservative and others more liberal, and therefore the judges in those areas might apply even the rules that exist a little bit differently. So those are things that an attorney who works every day where you are going to know. So yeah, I mean, I can see a situation where there could be a trade secret situation in a salon. I think your average general salon without any of those factors, probably not. But again, that can vary. And then the other thing that can change by state is what's considered a proprietary business interest. Most states do require some sort of interest of the business in having the non-competition agreement, right? But what qualifies as that interest can change. Some states, client goodwill is considered a proprietary business interest. So the goodwill that you have built up with the clients of the salon is considered an interest that an item that the business has an interest in maintaining, and therefore they can have a non-competition agreement directed at protecting that. It can also be confidential information like your client records, those sorts of things. Those can also be subject to a non-solicitation agreement, but in some states those are a basis for having a non-competition agreement. And so again, that varies by state.
Wow, there's a lot that goes into this.
That's I know.
Why I'm really glad that we're covering it, because we see so often in the various groups, you know, people talking about non-competition agreements, and you'll see tons of comments that say they're not enforceable. But I think it's important that we go over this, because I, and my course of, you know, work with, you know, coaching and consulting, have actually seen them stand up in court more than I've seen them not. So it's, you don't want that to come back. But so then what would you, if I was going into a salon that I've been working at for over a year and they want me to sign one of these contracts, how does that work out?
So again, it varies by state, which is going to be the refrain for this whole conversation. But specifically, just so everyone can kind of understand why it varies by state, when you're looking at a contract, any kind of contract, contracts have to have consideration, right? There has to be consideration for the contract, which is sort of what is each party getting out of the contract, right? So when you are hired, obviously the consideration is you're being hired and going to be paid the salary that's in the agreement, and so that's the consideration. But when you've already been there a year and then they hand you this new piece of paper, the question then becomes, is ongoing employment sufficient consideration for that new contract? And the answer is, it depends on your state, because in some states, the courts have ruled that that is sufficient consideration. In some states, the courts have ruled that is not sufficient consideration. And then in some states, there hasn't been a ruling on it yet. So maybe. And so the other thing is, if there's something else that's going along with that, that might be sufficient consideration. So for example, are you getting a promotion?
Right.
So, okay, well, we're going to promote you to senior stylist.
Yeah.
But then that's probably sufficient, because there's something additional that the employee is receiving in exchange for that agreement. But if we're talking about a straight, nothing else is changing, the salon owner just has talked to a lawyer or something and decided they need to have a non-competition agreement and wants you to sign it, whether or not that's going to be enforceable is going to depend on whether or not ongoing employment is considered sufficient consideration in your state.
So then, to kind of back up here, what about if we're going to a new salon that I want to work at and they want me to sign either of these contracts? You
So
kind of on it.
Sorry, go ahead. What was that?
You kind of touched base on it.
Yeah, I mean, I think that, first of all, again, want to separate non-solicits from non-competition agreements, because I think reasonably you should expect that there's going to be a non-solicitation clause in an employment contract for a salon. That's pretty standard. There might be somebody that doesn't do it, and that's, certainly their prerogative. You're certainly not required to, but I think that's a pretty common clause for salon employment contracts, that, hey, the clients are the clients of the salon. Now, we've had lots of discussions on the boards. This comes up all the time. You can't control where people go, and that's true.
Right.
So a non-solicitation agreement doesn't mean a client can't come to you. It's saying you can't reach into the business and pull the client out. If the client wants to come to you and they find you and they schedule with you, that's a separate thing. But you can't direct solicitations at the clients. You can't, often they'll say, you can't remove client records from the salon or copy client records. And those are all pretty standard provisions. And so obviously don't sign anything you don't want to sign. And
right.
If you're concerned about how a contract is going to affect your legal rights, you should have an attorney in your jurisdiction review it, because they'll be able to tell you exactly in your jurisdiction what's going to be enforceable, what's potentially not enforceable, and what it would mean, because sometimes the way they're worded, it can be hard to, what is this actually going to do? What's the effect really going to be? But just broadly for non-solicitation agreements, those are pretty standard. So I wouldn't think anyone should be surprised by seeing something like that in a contract. Now, with a non-competition agreement, again, it varies so widely by state whether or not such a thing in a salon employment contract is going to be enforceable in that state. And I think, each individual stylist is going to have to look at their own life and situation, and then the restrictions in this specific contract, and think, well, is that going to be a problem for me if I leave? And if so, then you probably want to have an attorney look at it and let you know if it's enforceable as written. If not, why are parts of it enforceable and parts of it aren't? Because it really just depends on kind of where you think you might end up and what your plans are. Obviously, plans can change, so you want to have an understanding of how it could ultimately impact you and the decisions you make. But I think people should be very cautious, and this is kind of based on what you were talking about that we see going on in the forums a lot, of just don't assume that a non-competition clause in a contract is not enforceable. A lot of people get bit by that assumption. Definitely want to have that reviewed in your jurisdiction to figure that out.
Before, where there's a non-competition clause in a contract, or a separate one, contract altogether, where it went to court, and there were parts of it that were not enforceable, but the judge kind of made its own decision. Like, for example, they could not work for 2 years within a competing salon within a 20-mile radius. Well, the judge said, well, that's kind of too extensive. It could be 1 year and a 10-mile radius.
Right.
So they can kind of rewrite or, change what's enforceable too.
Right. So that, different things can happen ultimately if you do challenge a non-competition agreement in court. So something like that can happen. The other thing that can happen is there may be certain terms of the agreement that are not enforceable, but that's not going to void the entire agreement. So generally, when a court is looking at interpreting a contract, if there's a particular clause in the contract that is either non-enforceable, void, voidable, whatever, it's not going to be enforced. If the court can excise that section without affecting the rest of the contract, then that's what they will generally do. So for example, if you have a non-competition agreement, and this is just a made up hypothetical that is not any particular state's laws, but let's just say there's a state where in this particular jurisdiction, the courts have held 5 miles to be reasonable. And you can also restrict type of work, length of time, etc. And we have a non-competition agreement where everything else follows the rules, but it says 10 miles. The court could reduce it to 5, or the court could throw that restriction out, but leave the rest of the restrictions. So just because one particular term is invalid, that doesn't necessarily mean the whole contract's going to be invalid. So people want to be careful. One of the things I've seen is people saying, oh, well, that says 20 miles and that's unreasonable, so that's not enforceable. That's not necessarily accurate. That particular part might not be enforceable.
Make.
Right. And the court might determine that particular provision is not enforceable, but that's not necessarily going to void the entire non-compete agreement.
So are there ways to get out of non-competes?
So again, that's going to probably depend on if it's valid in your state, if it's void or voidable in your state. So for example, in Oregon, non-competition agreements that don't meet the rules are voidable. So that means they can be voided, but it takes an affirmative act of the employee to do so. So they're not just automatically not there if one of the terms is incorrect or it doesn't meet the qualifications. So different states also have different rules for that. Some of them may say that they're void, which is, completely doesn't exist. They might be voidable, which means they can be voided, but they're not void currently. They might simply be unenforceable, or, various combinations thereof. And so whether or not you can get out of a non-competition agreement is going to depend on sort of how they are viewed in the first place, as far as what state are they in currently? Are they valid? Are they voidable? What's the attorney working with and potentially getting you out of it? And again, was there sufficient consideration under the laws of your state for entering it in the first place? If there wasn't, you may be able to get out of it that way. And so, that's again a really fact and jurisdiction dependent question. Is it possible to potentially get out of one if something wasn't done correctly? Sure. But again, that's totally going to depend on the rules in your jurisdiction, what happened here, were the rules followed, was there sufficient consideration, all those sorts of things. And the other thing that can potentially happen is sometimes, any contract can be renegotiated, right? So there's also a possibility, sometimes people will do separation agreements. This is less common in salons, but more common in like tech industry and whatever, where they might do a separation agreement where, someone might agree to a lesser severance package in exchange for reducing the terms of the non-competition agreement or something like that. So there's kind of some different things there where potentially it could be renegotiated if the employee has something that the employer is interested in negotiating about.
So this next question came from one of our members. Can you show me an example of an enforceable versus a non-enforceable agreement and explain why?
No. and the reason for that is because it varies so widely. I could show you an enforceable Oregon agreement, but that's not going to mean anything in any other state. And so, this is really, and I know it's frustrating for people because they want to just have an answer. And some things are, a little bit more cut and dry because they have federal laws that apply to them. For example, another topic I know we're going to talk about another day is the whole 1099 status situation. And that there's a little bit more broad application of those sorts of things because there's a federal aspect to those rules. Non-competition agreements is completely state dependent. There is no like federal overarching rule. Even the extent to which I would say, I think most, if not all states have some aspect of a reasonableness component to non-competition agreements, even if they're allowed. It might be a reasonable distance or a reasonable time or a reasonable restriction on activity. But then you still then have to, okay, well, what have the courts in that jurisdiction determined is reasonable, right? Because reasonable doesn't just mean what you think is reasonable. It means what the court has determined is reasonable given similar circumstances. And that can vary depending in some states on the industry. What's a reasonable time and distance restriction for, the manager of a tech company might not be reasonable for a hairstylist. So that can just vary so broadly that I can't give you an example of what would or wouldn't be valid. I would say if you're a salon, certainly if you're a salon owner and you want to have a non-competition agreement, I would strongly advise having an attorney in your jurisdiction review and advise you about the terms of that document. And the other thing I would say is an attorney licensed in your jurisdiction does not mean the internet. And I say that because, there are different websites where you can go on and ask a question of an attorney, and an attorney will, give you some sort of an answer. Or, I think LegalZoom has something where, you can ask a general question. But unless you are actually hiring an attorney to work on your issue who is licensed in your jurisdiction, there is no guarantee that that advice is going to be correct or applicable. And when you look at those, you'll usually see there are pretty broad answers. But if you have a document and you actually want to know, is this enforceable? You need to talk to an actual human being who is licensed and works where you are.
That's great advice. So we've kind of gone over that the difference between non-solicit is going to be about the actual, like, pretty much information and reaching out to the client.
Right.
And about how, like, the salon owner does kind of have some ownership over the client, like especially their information, and that, yeah, sure, the client still gets to make up its mind as to where they're going to go. Non-compete are going to be kind of about protecting the salon's investment in hiring you as an employee, and they're not necessarily a bad thing. And the biggest thing we've learned is that it is going to depend on your specific area as to if they're enforceable or not. So that's, I think, what Sarah and I both want to make sure that everybody understands is it's an individual situation. It can't just, a cut and dry answer on it.
Yes. And that's, it's very dangerous to go online and ask, is this enforceable? And then listen to the answers from people who do not live in your state.
Exactly.
Because it does not matter at all if an agreement is enforceable in Missouri as to whether it is enforceable in Florida. Zero. Matters not at all. So you really have to talk to somebody who's knowledgeable in your state.
So Sarah, I want to thank you very much for joining us today and answering all of our questions. And this is great information.
Thank you for having me.
Sarah's gonna hopefully be a regular on Legally Speaking, so we can get some of your guys' questions answered and topics covered. And until then, make sure you stand tall. Thank you.